afternoon. I am here with Mark Melsness, the designated broker for Spinnaker Property Management. Mark, how are you today?
I am super fantastic.
Nice to see you, as always. So, there are some things going on with property management laws, landlord-tenant laws in the Washington State Legislature that I certainly wasn't aware of, and many in our audience probably don't know about. It sounds like they're sort of have become news and now they're no news, but I'll let you kind of explain that, what's going on with that.
Yeah, so there were a handful of proposed laws that were in the legislature to be considered that would have altered a lot how landlords work within the new laws coming regarding the landlord-tenant laws. So they talked about just cause for notice to vacate from the landlord. They talked about how deposit dispositions and accountability was. They talked about how payment plans for fees beyond the rents to get in, and a few other things. And here just recently, about a week ago, a few of those bills have died in the House. So
what's the deposit deposition one? What does that mean?
So one of the ones that didn't make it was that the request or the law would have required the landlords to have itemized expenses with receipts to show those costs that were depreciated over time on a set schedule.
Wow, okay.
So it would have really created a large burden for the landlord to, in a short period of time of 21 days, come up with the costs of those repairs that were the renter's responsibility and get them in the disposition, which is the letter that goes out to the former renter with the check or the remaining of the deposit, if any, explaining what those costs were with the copies of the receipts and the depreciation schedule of that work, whether it be like an appliance, painting, floor covering, any of that type of items that we would be billing for.
So it's making the landlord very specifically accountable for how they spent the security deposit money.
Yeah, it is. And it's
or
also,
it would have.
It would have. It would have created a greater burden on the landlord to actually be accountable for that in the short window of time. We're already, at Spinnaker at least, and most professional management companies, laying out on the letter, the disposition, what those individual line item costs were, and if they were full or not full, like a full paint compared to a partial paint, or a full carpet replacement compared to a partial carpet replacement, and we would depreciate that over the 7-year period anyway. This is making it a law that the landlord has to comply with, which then in turn, if they don't, would have been had some punitive damages to the landlord.
Okay, got it.
Yeah. What also failed was the just cause. That was the big one, because the law would have required landlords to have a just cause, which we're not sure what just cause defined is yet, to actually ask a renter to move. So right now, the state requires 30 days notice, 60 days if you're in Tacoma, for the landlord to ask the renter to move. This would have had those same time periods, and it would have been a requirement for the landlord to say why they want the renter to leave, and it would have been just to ask, it'd have to have been just to ask the person to move. So you can imagine what the definition of just would mean. If the landlord wanted their property back because they wanted their property back, that would not have sufficed to ask somebody to move, even at the end of a lease or on a month-to-month.
So maybe they want to sell the property or do some improvements on it or whatever. This would have forced them to explain.
Yeah. Now,
and it would have had to been considered a just cause to ask them to move.
Now, selling your property probably would have fallen in the just cause, and as the conversation expands, it really brings into question why, if the renter doesn't have to give just cause, why would the landlord have to give just cause? And it's not about right or wrong, it's about balance, and having both parties have a balance and equity in the conversation, in the relationship created through the rental agreement.
And reasonable business transactions where you're not managing something to such an incredible detail that it's not productive or I don't know. I can just see how all of these things can be so incredibly time consuming and demanding on one or the other's time,
Sure.
almost to the point of,
Right.
yeah.
And the intention is to try, from the tenant unions or the advocate leaders, is to have some balance between the landlords and the renters. And people are stuck in the conversation of really where is the balance?
What does that
depending
mean?
on what side of the aisle you're on.
Right, gotcha.
Another thing that failed, or excuse me, that ones that haven't failed are the installment payments for moving costs and the mandatory delay in assessing late fees. So with the moving costs, right now the city of Tacoma has this program and they're looking to go statewide with it, is that anything beyond the actual rent cost itself, if rent's $1,000 and deposit's $1,000 and there's a pet fee of $500, that would be $1,000, $500, $2,500 total, that the law would have the renter, on a 12-month term or longer than 3 months, that the renter would have the ability to make 3 equal payments of that $1,000 deposit and the $500 pet fee, $1,500, in 3 equal payments at the time of move-in. So it would be the $1,000 with the rent with the $500, the next month with rent $500, and then the next month with rent $500. So there is this ability to, if they don't have the capital or the cash to pay all up front, this gives them the ability to get the home that they can have with their income that they just might not have the cash to get into.
Which is something landlords already do at times. It's just kind of formalizing that they have to do this, right?
Well,
or
in
it would
Tacoma,
have.
it's required.
Oh, okay.
Yeah, as long as the prospective renter requests it. It's not required to disclose it. This is actually setting it up so it's set up that way just across the board. We're not sure what amendments will come from this because they're working hard on both sides to try to get this finalized before this session is complete. And right now we're just not clear on where that is. The other thing that's still not clear is the delay in the late fees. So right now there is a lot of different ways that late fees are assessed across the board, from owner to owner, management company to management company. And what the law is intended to do is to move that date further down in the month so that they can have less additional costs if they don't pay on time, and giving them the ability to not get a notice to pay or vacate, which is now 14 days. So what that would do, though, is what the law has brought in, or what they have done in condition to try to get this thing to stay alive, is that they would retro, let's say that they had the late fee not kick in until the 6th, and if late fee is typically kicked in on the 4th, once you got to the 6th, you could backdate to the 4th and then go forward at that point. It's a little confusing. The idea is to have some leniency to the renter so they're not losing some of their cash because they can't pay on time. And as landlords, when we have conversations with prospective renters who are considering the homes that we have available, if they have a payday that's beyond our late day and they have that conversation at time of application prior to signing the lease, typically we're going to work that out anyway. This is requiring it to happen. And the other consideration is like, what is the cap on late fee and what is the structure in which you can apply the late fee?
Sure.
So we're not sure exactly how it's going to turn out, if it turns out, or when it does turn out. We're still in conversation. We got another couple of weeks before that all is going to be resolved, and it's going to be really busy between now and then.
Gotcha. Okay. So there's a couple that have been rejected altogether, and there's still some that are in discussion, and we don't know yet.
Correct.
So when will that resolve, you think?
About the next 2 weeks or so.
Okay, so maybe we can check back on a Wednesday in a couple weeks.
Yep. Actually, yep.
So is there a way for property owners in the area to have input on these decisions or observe the hearings or anything like that?
You can, of course, reach out to us here at Spinnaker Property Management at 253-830-5160. Visit our website. You can contact us there. You can also join in with the WUMFA, Washington's Multifamily Housing Association, become a partner there and get the legislative updates. And you can also work with Rental Housing Association of Washington, RHA, of Washington and be a member there, and that also keeps you in the conversation of the legislative updates.
Got it. So we'll also have a blog post with some of this information Mark's been
Yep.
talking about up on the site here in the next couple of days, so you could check the Spinnaker review on spinnakerpm.com for information as well. Super helpful. It's kind of an in-process thing, but it sounds like
Yes.
it's something that would be interesting to owners. I know if I was an owner, I would want to know what was going on and be able to have some input. So thank you, Mark, and we'll be talking more about this in a couple weeks and give another update.
Thanks for checking in.
All right. Talk to you again soon. Bye-bye.